Welcome back. Today, we're jumping right into this explainer, mapping out how the American legal system radically transformed over the span of roughly 150 years. We're going to look at the actual architecture of the law itself, tracing its evolution from a completely open, common law system into the massive administrative state we navigate today. And most importantly, we'll be looking really closely at the primary architect behind this whole transition.
Okay, let's dive right into this with a question that, honestly, might sound completely foreign to us today. What if practicing law wasn't a licensed privilege, but a common right? Right now, we just kind of assume you have to pass the bar, get a license, and join a professional guild just to step foot in a courtroom. But as our source material reveals, that was absolutely not the baseline of the American legal system, not even close.
To really grasp the magnitude of this shift, look at the stark contrast between these two eras. It's like night and day. Before 1878, the system was governed by an open practice of common law. Everyday juries actually held the power to judge both the facts and the law itself. Now contrast that with our modern system. It's defined by administrative fiat, a mandatory bar association that you literally have to join, and heavily marginalized juries. Neutrally mapping out how we leapt from one reality to the other is the core mystery we're solving today.
Part 1. The Common Law Era. So, to figure out how this all happened, we have to travel back to a time before the modern legal profession even existed. Here's what the landscape looked like before 1878. Common law dominated everything, and practicing law was largely open to the public. Kind of like the Wild West, right? Juries held incredible power. They judged not just what happened, but whether the law itself was actually just. And then there's equity, which is basically a judge's power to use their own discretion to decide what's fair. Well, back then, equity was strictly limited. Early Americans were super wary of giving a single judge too much unchecked power, so equity had to rigidly follow the established law.
Which brings us to Part 2. The bar is born.
Let's move to the timeline and see how this builds. What was the inciting incident that set our modern system in motion? Well, it all starts right here. In 1878, the American Bar Association is founded. For the very first time, the legal profession organizes itself as a national force. By the late 1800s, you have the progressive era pushing for expert, efficient government. Driven by this desire for standardization, the ABA actively supports giving judges way more discretion. And this builds right toward 1895, where jury power takes a massive hit, which perfectly lays the groundwork for 1921, a year that alters the profession forever.
Actually, let's zoom in on that middle date for a second. 1895. The Supreme Court decides a case called Sparfy v. the United States. Guys, this is a monumental shift in legal architecture. The court rules that juries are strictly finders of fact, completely ending their historic role in judging the law itself. During this era, as equity expands, the ABA throws its full support behind greater judicial discretion and the growth of administrative power. So the balance of power officially begins moving out of the jury box and directly into the hands of legal professionals.
Moving on to Part 3, the mandatory movement.
This takes us right into the 1920s, where the transformation really kicks into high gear with this concept of the integrated or mandatory bar. Think about it. Imagine if, to do your current job, you were legally forced to join and pay dues to a single private guild. That is exactly what happened here. North Dakota pioneered this framework in 1921. The moment this passes, the practice of law officially flips from a common right into a licensed privilege controlled entirely by a private organization. And, unsurprisingly, the idea of lawyers voting to give themselves a monopoly proved to be a pretty popular idea within the profession.
Once established, the mandatory bar's influence spread like wildfire. Florida integrated its bar in 1949, and a whole wave of states quickly followed suit. The bar didn't just become a fun membership club, it secured total control over the vital mechanics of the justice system. They became the sole authority on licensing, setting the ethics rules, enforcing discipline, and ultimately acting as the gatekeeper for who even gets access to the courts themselves. They controlled the whole shebang.
Part 4. Merging law and equity.
All right, with the professional mechanism locked firmly into place, we arrive at a massive change to the actual rules of the game. 1938 is absolutely crucial here. That year brings the creation of the Federal Rules of Civil Procedure, which effectively merged law and equity into one unified system. Remember how we saw earlier that equity, that discretionary power of a judge, was strictly limited? Well, this merger, heavily supported by the ABA, essentially wiped out those traditional boundaries. It allowed discretionary remedies to completely dominate the modern system.
And the rules just kept fundamentally changing across the board to support this new reality. In 1946, the Administrative Procedure Act is passed. The APA is basically the constitution for federal agencies, and the ABA played a massive role in shaping it to protect the new administrative state. Then, through the 50s and 60s, the Uniform Commercial Code is adopted nationwide. The bar helps implement this entire framework, which moves everyday business away from strict, traditional common law contract rules and toward much more flexible, equity-influenced standards.
And finally, Part 5, the modern gatekeepers.
So, the crucial point is, this timeline brings us right up to the present day, revealing the ultimate role of the bar. From the 1960s onward, administrative adjudication absolutely explodes, immunity doctrines expand, and juries become deeply, deeply marginalized. And sitting right at the center of this massive bureaucratic web is the mandatory bar. It acts as the ultimate gatekeeper. It trains lawyers specifically to operate inside this administrative framework, disciplines anyone who challenges the system too aggressively, and fiercely protects the new equity regime.
Which brings us to the core thesis from our source material. The bar didn't just witness the drift, it helped engineer and then guarded the replacement of law. This is exactly why understanding this history matters so much for anyone participating in modern society today. The transition from a strict common law system to a massive administrative state, it wasn't an accident. It was a highly engineered, professional transition made possible because a single organization gained total control over who could practice law.
Once that old system was locked out, it became nearly impossible to defend from within the profession itself. Which leaves us with a final provocative thought to chew on today. If the bar guards the modern legal system, who guards the bar? Thank you so much for joining me today. Keep asking questions, keep looking closely at the architecture of the systems around you, and I'll see you on the next Explainer.